you have to learn contract drafting. Contract drafting is one skill for which there is almost unlimited demand, and very few lawyers actually know how to draft, review, negotiate commercial contracts. Although it is surprising, just look around yourself, ask your peers, ask your colleagues. Most of them have no experience, no skills in this area, and that is your opportunity. If you learn contract drafting, you can get results really fast, and I want to show you how. You just have to register below with your phone number and email ID. I'm going to send you a bunch of really useful resources that you can start using right now. Plus, my colleague is going to call you and help you to create a personalized roadmap that you can use thereafter to build your career in contract drafting, to build your knowledge in contract drafting, actually draft contracts, and even get the jobs and the kind of freelance work that you may want. Not only in India, but you can learn even US and international contracts. You can really open up international career opportunities. Register right now, and we hope to talk to you soon.
Hey, did you know that pivot tables is one of the most powerful features of Microsoft Excel? I can help you master this tool in just 3 hours so you can answer key questions related to your company or department KPIs at the click of a button, back your decisions with 100% accuracy, build beautiful and interactive reports and presentations, and do so much more. Hi, my name is Jatan Shah. I'm a Microsoft certified trainer and the highest endorsed Excel professional in the world. I invite you to join me for my live 3-hour pivot tables workshop where I'll make you a certified pivot table expert in just 3 hours, even if you have no prior knowledge about it. More than 35,000 students have already completed the workshop and are now saving hours of their time creating value at work and having a faster career growth. So, what are you waiting for? Click on the link below, reserve your seat for the workshop at just rupees 299 right now, and when you do, get bonuses worth rupees 9,000 for absolutely free. Click on the link below and I'll see you inside the workshop.
Today, the very basic concept of FIR, regarding which a lot of confusions are there, I would be sharing it with you. See, FIR has not been defined under CRPC, but इसका जो मतलब है वो इसी टर्म के अंदर छुपा हुआ है. First
ये
information
लिंक
report
शेयर
is
करना है आपको लिंक शेयर
the information which is given at first point of time
लिंक शेयर किया है एक
by the informer, the officer in charge of the police station, the area where the offense has been committed. But section 154, it lays down the mechanism as to how the FIR is to be recorded. Simple definition is that जब कभी भी कहीं पे भी क्राइम होता है, उसकी जो हम रिपोर्ट प्रथम सूचना पुलिस को देते हैं वो आपका FIR है. But what is the utility, importance and significance of this document? This is what we need to understand. See, this is a very vital document, but still it is not a substantive piece of evidence, because just on the basis of this document, we cannot convict somebody, right? This document is so important, actually it lays down the basic structure for the whole case. Although it has been held in number of judgment, it is not an encyclopedia. It does not need to contain the minute detail of the incident, but still its importance and significance
हटा ही
is
देता है
so
इसको
vital.
इमेज का तो कोई इमेज लोगों तो लगाई
Which
है
provides an aid to the prosecution and also to the court to adjudicate the
हेलो
matter
हेलो
in a fair manner.
यार माइक लगा इसका
So, what is the object of the FIR? See, I am a police officer. officer in charge, sitting in my room, somebody comes with the complaint, I immediately get into action. So from the informer point of view, he sets the criminal law into the motion on the strength of this document, and it actually kickstart me to take the action or proceed. Strongly resisted, can it be quashed? Or if after registration of FIR, a compromise takes place, can it be quashed on the basis of the compromise? What is zero FIR? Now, in the detailed lectures, we would be discussing all these concepts in the light of the judgments laid down by the Honorable Supreme Court. Thank you very much for hearing me patiently. Keep in touch, subscribe, share, and press the bell icon for updates. Thank you. Hello friends, hope you are fine and doing well. I once again welcome you with yet another topic which is very, very interesting and not very complex, I would say, but very important from the investigation point of view or from the point of view of establishing the guilt of the accused. See, CRPC NVC's provisions mainly to secure the interest of the state, to maintain the public peace and order, and to ensure the individual liberties. Individual liberty has always been considered on the highest pedestal for the reason that it is so sacrosanct, even have been recognized by the Constitution of India under Article 21 as a fundamental right. Now, as we studied the topic of arrest, that somebody's liberty should not be confined without the due process of law or without the authority of the law. Clearly, the search should not be conducted randomly unless it is so warranted and there are sufficient grounds or the reason with the authority concerned to do so. The provisions have been envisaged under section 91 to 100. These are the general provisions. 101, 102 also describe certain things about the search as to how it is to be conducted. Even section 103 says that in the presence of the magistrate, the search could be conducted. So 91 to 103 deals with the general provision of the search. Section 165 and 166, as we read in chapter 12 of the investigation, it talks about the carrying out the search during the investigation process. Now, when the case is registered, FIR is registered, police is investigating the matter, without warrant, there are certain provisions that is section 166 carry out the search, provided they feel sufficient, the possible evidence is there. Without warrant. Now, since I said that it's a most important function, I will just illustrate here. For example, a crime takes place. Say the B has stabbed A. A is lying on the floor, blood is oozing out. A lot of people gathered. C is the one who has actually seen the occurrence taking place. Police come on the spot and start taking the statements under section 161 from the passers-by or the persons who have actually seen the occurrence. C states that he has seen B stabbing A with the knife. Now, B is ultimately arrested. During investigation, he suffers a statement which is called disclosure statement with regard to recovery of the knife. Because in section 27 of the Indian Evidence Act, we will study that only the part of recovery which led to the recovery of an weapon or any article which has a nexus with the crime is admissible in evidence. Otherwise, section 25, 26, statement before the police, as you all know, is not admissible, but only up to the recovery part it is admissible. Now, B has got the recovery done to the police of a knife with the help of which the crime has taken place. Now, this knife is required to be produced before the court for the inspection and to establish the guilt. Because the statement of the C will not be sufficient enough to establish the guilt, there has to be some substantive corroborative evidence. What is substantive evidence? Why it is required corroboration? We would be discussing this concept in the forthcoming lectures. But here, since we have been talking about search, I just want to explain you as to what is the importance of the search. Since police has reached at the spot of occurrence, collected the knife, blood-stained cloth, even blood samples, from they collected, and all the samples and the knife is sent for the chemical examination. Now, all this evidence is available before the court now. The court solely cannot base the conviction of an accused on the statement of the C. The corroborated with other material evidence. Now, the chemical examination report would be taken into consideration. If it says that blood on the knife, it actually matches with the blood of the victim or the deceased, or it has a fingerprints of on the knife, or even the blood-stained cloth of the deceased or the victim matches with the blood sample which was sent for the chemical examination. Now, this material is sufficient enough to corroborate the evidence and to base the conviction of the accused. Therefore, search and seizure plays a very important role. It has always been, as far as possible, been done by the experts, people who are having a specialized knowledge and who are well versed with the norms and procedures also. Because in case the procedure laid down under CRPC is not followed, then it would really hamper the case of the prosecution. It may be proved to be fatal. So such a eventuality should not emerge or arise. The Honorable Supreme Court in the various judicial pronouncements have said there are specialized agency who is to carry out the investigation, who is to conduct the investigation, should be engaged, especially for the heinous crimes or the crime which are white collar crime or wherein suppose the forged documents were being used, or cyber crime, or the cases pertaining to terrorism, drugs, and all heinous crime, murder, rape, these kind of things. Wherein Supreme Court has said that a specialized agency should be engaged, and so that the evidence could be collected in a just and fair manner, and it should, when it is put to the judicial scrutiny in the court of law, then guilt could be established. Now, Supreme Court has come if the evidence was available. For example, a crime is taking place in an open market. There was a CCTV camera footage. If the footage has not been recovered from that particular place, which was in the knowledge of the investigation officer, then investigation officers would be held liable for that, and very serious consequences would be emerged against him in case the material evidence which was available were not taken into consideration. So, my dear friends, my only concern was to say that it is a very, very pious, special, and the moral or the legal obligation of any officer, because ultimately on the basis of the collection of the evidence, the guilt is to be established, because court is not coming physically. Whatever is produced before the court has to weigh that evidence, and accordingly the conviction is to be given or the guilt is to be established. So it has to be by the trained experts, experienced, and the people who are having a specialized knowledge to this effect should be engaged for these purposes. Now, Section 3 of the Indian Evidence Act says that it includes all the instrument by which relevant fact can be brought before the court. So whether it is a document, article, weapon, anything that could be brought before the court for the inspection and for establishing the guilt. Now, Section 2H defines the investigation, which says that it includes everything under the code for the collection of the evidence. Now, court can issue summon under Section 91. Now, what is summon? See, I would be recording a different lecture on summon and warrant in detail, but herein what you need to understand the meaning of the summon. It's a command of the court to an individual to produce, document, or anything. So if something is very vital to prove the fact in issue or the relevant fact or the matter before the court, then the court may summon the concerned person to come and produce that document or that thing. It's a command by the court. Section 91 defines the summon could be issued not only for the appearance of the person, but also the command could be given to produce the relevant thing also. Section says that if anything is in possession of the postal or telegraph authority and which is required to determine the case, to adjudicate the matter before the court, then it could be issued to the authorities concerned. Now, Section 93 is very important. It's a warrant. Now, I said that under Section 165 and 166 of CRPC, when the police during the investigation is not required to obtain a warrant, wherein the general provision says that warrant is required because the individual liberties are sacrosanct in nature, should not be curtailed without the due process of law. Therefore, it is mandatory for the police to obtain a warrant. Now, both executive and judicial magistrate are empowered to issue the search warrant. Now, under what circumstances this warrant should be issued? Now, we will read it further. Under what circumstances warrant should be issued? Now, Section 93 says that warrant could be given to the police authorities to conduct search or seize some article, object, vehicle, premises, area, whatever. For these reasons, for these things, this could be given. Now, why it is required to be given? Section 93 speaks about two things. One, that a person who is in possession of these things, an article, and not coming before the law, despite of the summon, that then to ensure its presence or its availability in the court, the warrant could be issued. One. Second, if it is not known to the court as to with whom it lies or in whose possession it is, then in order to conduct a search, this warrant could be issued again. Fine. Section 94 says that if the police has a reasonable belief, or the court also is aware of the fact from the police itself, that certain stolen property has been deposited somewhere and this is also being sold. Now, in order to conduct search at that particular premises or area or location, the search warrant could be issued under Section 94. Now, Section 95 says that if some newspaper agency or some publication house is publicizing the news which ultimately attracts the offences such as 124, sedition, 153A and B, waging war against the government, 292, 293 and 295A. 292, 93 deals with the obscenity, and 295A, I mean, if you have been spreading some news which creates the hatred and the, feeling of disharmony, the religious sentiments you are going to hurt. If this kind of, things are being done by any publication by way of a book or document or newspaper or a magazine, then the warrant could be issued to conduct search and seize the publication house. Now, those who are into a regular practice would tell me, those who have been viewing it will tell me what is the remedy before the publication house, passing a comment in the comment box. What is the remedy before the publication house if in case it is forfeited by the police on account of the facts we have just discussed? Fine. Section 97 further says that if somebody has been confined into illegal custody, then the search warrant could be issued. The corresponding provisions in this regard we read in Constitution. The writ of habeas corpus we usually file before the High Court, fine, wherein the directions are given, and even the warrant officer is appointed to conduct the raid where the illegal confinement has taken place, but the concerned magistrate or the executive magistrate even, they are not helpless. If they have a strong reasons and belief that somebody has been confined and an application comes to them, the order could be issued to conduct search and get the person released from the clutches of that fellow who has kept the person under the illegal confinement. Now, Section 8 says that if a female below the 18 years has been abducted and confined, then the search warrant could be issued to get her released also. So when search warrant could be issued, under what circumstances, I have just explained it to you. Now section 100 is very important, which deals with the general provision, now how the search is to be conducted. And what considerations are to be kept in mind by the police so that he could prove the recovery in the court of law, fairly, and the case of the prosecution doesn't turn out to be fatal when it comes to the judicial inquiry. Now, first and foremost thing is, because as I said earlier, that it should be done in a very specialized manner, keeping in view the parameters laid down under the code. Fine. The person concerned has to join 2 independent witnesses while conducting the recovery, while conducting the search or seizing the things from the premises or from the spot of occurrence. Now, 2 independent witnesses has to be there, and they should be the inhabitant of the same locality. In case they are not available from the same vicinity or the same locality, then the reasons are to be given, and the 2 persons could be joined from some other locality also. The occupant of the premises should be present. In case he is present there, then he should be joined. Signature of the independent witnesses, the concerned and the occupant should be taken on the research memo also. Why so? Because when later on the question comes to the recovery in the court of law, these witnesses could be called there, and the genuineness of the recovery could be established in the court of law. If a female is to be searched personally, then it should be by the female officer in due regard to her dignity should take place. Then the person, almost everything I have, I think I have covered. Yes, if a person refuses to join, if person, despite of the request of the concerned police officer, refuses to join, then the provision of section 187 IPC could be attracted against him. He could be booked for an offence under section 187, because it is a moral obligation of every citizen to help or to provide aid to the police agency so that they could work effectively and smoothly, and because ultimately they have been discharging their functions or performing their duties to safeguard the interest of the public only and to maintain the law and order. So it turns out to be our obligation to aid as far as possible should be. Proceedings, vitiate the trial, fine. Lecture we would be discussing this aspect where the proceedings of trial proceedings are to be vitiated under section 460 and 461 CRPC. We will read as to how fatal the procedure or the would be in case the compliance is not made. One last thing, see, since I said that it's a moral obligation of us, once the person is having a search warrant, he comes to raid the premises to conduct the search, he should be given free ingress to that. If the ingress is not given, the passage or the path or the ingress is not given to him, despite of the fact that he shows you a search warrant, then he can use the reasonable force as provided under section 47 subsection 2 of CRPC. Now, this force should not be used unreasonably or in an unjustified manner, but yes, the section provides in order to collect the evidence. If where it is required, then the necessary reasonable force, the window or the door could be broken by the concerned authorities. And in case of resistance or in case of not providing the free ingress to the things. So this is all, my dear friends. We have discussed the concept of search and seizure. It is one of the most important function after the arrest of the accused during investigations or otherwise, because police has to perform two functions mainly: to prevent the crime, or in case the crime takes place, then is to investigate in a just and fair manner. So while preventing the crime, if they get some substantive information from some source that some illegality is going on, then they are not helpless. They can, obtain the warrant from the concerned magistrate, whether it is a executive or the judicial, and they can raid the premises, can conduct the search and take things in their control and custody or in possession. So thank you very much. See you. So today the topic of discussion is Indian Registration Act. This act is very small but very significant from examination point of view, as well as anybody who is in practice, he or she must know the importance of this act. Fine. So should we wait for some more students to come, or say yes, if you are there, you are, if I am audible and visible to you, if everything is fine, then we can proceed with the lecture. See, initial 5-10 minutes of my lectures are very important, which are not required to be missed, because once you understand the definition part, the conceptual clarity about the object and purpose of the act, then things become very easy for you to understand it. That also create a sort of interest, and you start liking, loving the act, and once you understand the theory, or you can say the gist of the act. See, Indian Registration Act 1908 deals with the registration of documents. Now, why do we require to register a document? First, you need to understand it. Fine. Now, through any document, if some interest title is either declared, created, assigned, or extinguished in somebody's favor, that requires our registration. Now, for registration, some books and registers are kept at the office of the registrar, which we will read in the act. Fine. Therein, the endorsement or the entry pertaining to that particular document which has been executed by the party is registered. Now, the purpose of registration is one, that you can have an authentic proof of the document which has been executed. One, so document become the authentic one and it got the legal sanction. Two, that parties to the transactions becomes, absolutely free from any kind of fear or threat to their right or the title which has been created through that document. Fine. Third, anybody whosoever is going to enter into a transaction with regard to the property which has been endorsed in the document, he or she may know the status of the property quickly. Fine. So, with the help of it, you can say that you can prevent the fraud also. Fine. If say A and B, there are two parties, they enter into an agreement, although they enter into an agreement privately, but once they registered it with the office of registrar, who has been designated and appointed by the state government, fine, whose work is to upkeep and maintain the record and give an authentic, proof of the transaction of the document, fine, not transaction of the document, fine, then you are secure, and the persons whosoever is coming, in future, like, to deal with that property, which has been inscribed in the document, he can know the status and he would be, free. And this document is a public document. One can obtain the certified copy of it after paying the requisite fee also. Fine. So the job of the department is to preserve the document so that preserve the document so that the fraud could be prevented. One. Two, authentic proof could be maintained. Fine. And three, the sanctity to the transaction or the title. Otherwise, how would I come to know that this property belongs to me unless or until it is registered? Or how could the world at large would come to know unless or until it is registered? So registration has been meant for this purpose only. Fine. So in section 17, certain documents have been provided which are compulsory registrable, and in section 18, some documents are there which are optionally registered. So we will read these two sections are very important from registration point of view, section 17 and 18. Fine. So section 1 talks about the extended application, J&K is now part of it, so it applies to the J&K as well. Section 2, as usual, as per the other act, defines certain definitions. For example, here in the definition of lease, definition of immovable property, fine, and definition of addition, and the court, India, etc. These have been provided. So lease, immovable property, movable property, and addition. These are very important definitions. Fine. Section 3, that talks about the appointment of the Inspector General of Registration. The person who is heading the entire department is called the Inspector General, but these powers are further designated and delegated by the state government to the registrar concerned, who act as a registrar once they deals with the registration of document, or who act with the who act as a collector when they perform the revenue job. Revenue collection, or just, so then they call the collectors. Fine. So they are delegated the powers of the Inspector General of Registrar. So again, there are state, district, sub districts. Sub registrar, registrar. They are the designated authority under the acts. So 3, 4 is repealed. Section 5 deals with the district and sub districts, and section 6 deals with the registrar and sub registrar, as I said. Fine. And the section 8 deals with the inspector of registration offices, and section 9 has also been repealed. Section 10 talks about the absence of registrar if the vacancy is created, absence of registrar in a particular district. Fine. 11, absence. And the most important, actually the act starts from section 17, which talks about the compulsory registrable documents. Fine. Section 18, optional. Then important section you can write down. 19 is important in this act, which says that when can a document be refused to be registered by the registrar. So if section 19 says, if the language is not understood in which the documents have been this has been drafted, that language is not understood, because that language is not the language of that particular state where the document is to be executed, unless or until it is supported with the translation. Fine. Then it cannot be registered. So the registrar concerned could refuse to register the document. Fine. Similarly, section 20 say if in the document there are interlineation blanks, fine, or alterations, fine. So then it could be refused unless it is signed by the attester. Means the persons who are executing the document, they sign if some mistakes has occurred, like some error has occurred, and some interlineation has been made. Unless or until that is removed, then the document could not be registered. Fine. So section 22 says that if document is pertaining to immovable property, wherein the maps, boundaries, directions are required to be mentioned, if the description of the property is not there, then also it could be refused to be registered. Now section 23 to 26 deal with the time and time of the registration. So time for presenting the document is, say today we have executed the document, within 4 months from today it has to be referred to the sub registrar for the registration. So 4 months have been provided under the act, section 23. Fine. Section 23A, this was incorporated later, A, it talks about the re-registration of documents. Suppose I'm a sub registrar, the document was produced before me for the registration, and I got it registered, but later on I came to know that the persons who have actually produced the document was not authorized to do so. Fine. So he was not supported with the kind of right power of attorney. Then if some complaint or objection with regard to the document is made, then I could get it re-registered also if it is produced by the appropriate person. The person who was actually authorized, if it is produced by him, then it could be registered. Fine. So re-registration जो है वो बाद में incorporate हुआ तही से. Then if several persons are executing the document, 24 deals with that. Say first A signs, then B signs, then C signs, and D signs. The D suppose is the last person who signed the agreement, who executed the document. Now the period is to be reckoned from the last person's execution. Fine. So section 24 say so only. Okay. And 25 says if the delay on the part of the parties concerned who were supposed to produce the document for the registration, they could not present it due to unavoidable circumstances, then that could be considered. Fine. Unwarranted, unavoidable circumstances due to extreme emergency, if one could not come, fine, then that document could be considered, means delay could be condoned under this section. Section 25 says so. Section 26 talks about the document executed out of India. Now, if some documents have been executed outside India and the person concerned has brought this document, it means he has arrived in India. Now, from his arrival, the 4 months is asked to be computed. Fine. So, section 27 says that if document, 26 says if document executed outside India and from which date it is to be registered, from the arrival of the document in India, 4 months is to be counted. 4 months are to be counted. Fine. Section 27 onward deals with the registration of wills. Fine. So, this is again important, but it requires a very exhaustive and lengthy discussion on this topic as to how the will are registered during the lifetime. How can one deposit the will before the registrar? There is a complete procedure. What are the register required to be maintained, and how it is to be opened after his death, who will open it, and how the property which has been mentioned, the immovable or movable property which has been bequeathed by the person, deceased person, to be distributed. These all provisions we will read in detail. Now, इसके अलावा जो अभी important section है, that is from section 47 to 50. These are very important. Effect of registration and non-registration. Fine. Which would be having a supremacy, registered document or the unregistered document. Fine. If it is, document has been executed and not registered, but later on the same property has been, registered. Fine. Registered in somebody else's name, then what would prevail, what would be the valid one, and what would attain the supremacy. Fine, these we will read in section 46 to section 50. इसके अलावा जो important है, power of the registrar, how the record is to be maintained, what are the registered one is supposed to maintain. Fine, if he refuses to register the document, then what is the remedy before the aggrieved person? Okay, where could he go? Within how much time frame can he file an appeal? Fine, these kind of provisions are there. So, in a way, this act is very, very interesting, very significant, and although it contains number of provisions, but the important one I have just highlighted. Fine, section 17, 18, which you are not to leave, then section 20 to 25. Fine. And then section 46, 47 to 50. These are the important provisions we will be discussing during the lecture. Now, let us come to the question. I would try to explain the concept briefly while attempting the questions. So, first question is lease has been defined in Registration Act, Transfer of Property Act, General Clauses Act, only A and B. Please answer, please. Lease. Registration Act में तो ये mention है, TPA में भी ये मेंशन है, जनरल क्लॉजेज एक्ट में कहीं मेंशन है लीज, और ए एंड बी में. योर आंसर प्लीज. ए, प्रिया, यू आर सेइंग डी, द जनरल क्लॉजेज एक्ट लीज इज डिफाइंड. Now, we need to see the definition of general clauses. See, immovable property, तो I am pretty sure it is at 3. Registration, transfer of property and general clauses act में immovable property का definition तो है. Fine. अब lease का definition general clauses act में होना चाहिए, ठीक है? But I am not pretty sure, so we need to see it. We need to verify it first, and then we will attempt this answer. Priya, if you are so sure, you can give the reference. Section number of where in general clauses act it has been mentioned, or you can Google it right now. Fine. Anyhow, next question. In the Registration Act, immovable property has been defined under section. So this is very easy to attempt. उन कौन से section में Registration Act में जो है immovable property define है. See, immovable property का यहाँ बहुत ही exhaustive definition मिलता है. ये केवल ये नहीं बोलता कि land and building, ये बोलता है even right to hereditary allowances, fisheries, waste. Fine, अगर आपने मतलब एक sort of orchard भी लिया है, है ना, तो उसकी भी जो इनकम है जो प्रोड्यूस है, that would be considered as an immovable property. If you have taken the contract of mining and you have been digging some minerals or mines like out of that land, that would also be considered as an immovable property. तो ये concept registration act में इतना exhaustive क्यों है and why this definition has been provided so, ये हम लोग जब lengthy discussion करेंगे immovable property के ऊपर में तीनों का registration act का, general clauses act का and TPA का, ठीक है, हम लोग जिस देखेंगे कि why so, like तो यहाँ जो definition है that is very exhaustive 2(6) में है, ठीक है, and TPA में भी define है और general clauses act में भी define है immovable property, but यहाँ 2(6) is the answer. Right? Good. The word purport or operate in section 17(1)(b) refers to the ultimate consequences of the instrument, immediate intention of the instrument, collateral effect of the instrument, all the above. Answer it, please. See, the very important definition which you have to keep in mind is document of testamentary and non-testamentary documents. Fine. Testamentary, as the name suggests, इसको आप याद रखिए हमेशा. It is my testament, my will. Fine. After my death, the property would be bequeathed to so and so, so and so, so and so in this ratio. Fine. So that is what is testamentary. So the document apart from the testamentary, all others are non-testamentary. Now, non-testamentary documents are those documents, the moment you execute the document, the moment we execute the document, it becomes operative immediately. मैंने आपको प्रॉपर्टी सेल किया, नाउ द इमीडिएटली और एग्जीक्यूट किया डॉक्यूमेंट, द यू बिकम द ऑनर, मीन्स यू आर कंफर्ट विद द टाइटल, यू बिकम द ऑनर. फाइन. सो दैट इज व्हाट अ नॉन टेस्टामेंट्री डॉक्यूमेंट इज. क्योंकि नॉन टेस्टामेंट्री डॉक्यूमेंट 17(1)(b) में यूज़ हुआ है और नॉन टेस्टामेंट्री डॉक्यूमेंट आपको जानना इसलिए ज़रूरी है बिकॉज आपका ये पूरा का पूरा रजिस्ट्रेशन एक्ट है जो उसके अराउंड रिवॉल्व होता है, ठीक है, तो इसलिए आपको इसका डेफिनेशन का पता होना चाहिए, ठीक है. तो अब ये क्या है, the word purport or operate in section, purport or operate means purpose and operational, the ultimate consequences of the instrument, immediate intention of the instrument, collateral effect of the instrument. So answer is all the above. Priya, you're right. Virender, you're right. Absolutely right. Okay? But the definition is that the document which becomes operative immediately soon after its execution is called the non-testamentary document. 17(1)(d) of the Registration Act applies to a lease for any term exceeding 1 year, a lease from year to year, a lease reserving a yearly rent, all the above. 17(1)(d) में लीज का डेफिनेशन दिया गया है कि वो 17(1)(d) जो है वो कंपल्सरी रजिस्ट्रेबल है. तो क्या वो 17(1)(d) बोलता है कि एनी लीज विच इज एक्सीडिंग 1 year of time और ईयर टू ईयर एक्सटेंडेबल है और लीज विच इज रिजर्विंग ईयरली रेंट. सो योर आंसर प्लीज. Priya, all D, okay, Virender D, Seema Arora D, absolutely right. So this is the definition provided. See, lease if it is lesser than a year is not required to be registered. Fine. तो यूजली हम लोग देखते हैं जो हम रेंट नोट या रेंट डीड बनाते हैं इन ऑर्डर टू अवॉइड दी रजिस्ट्रेशन फ़ी, हम लोग 11 महीने का करते हैं, ठीक है, ठीक है. क्यों करते हैं? क्योंकि उस पर हमें रजिस्ट्रेशन करवाने की ज़रूरत नहीं है, रजिस्ट्रेशन फ़ी हमें पे नहीं करना पड़ता, ठीक है. बट अगर आप एग्रीकल्चर लैंड के लीज के लिए जा रहे हो तो इट इज़ ऑलवेज इन द बेस्ट इंटरेस्ट ऑफ द पार्टीज कंसर्न दैट इट शुड बी फॉर द लॉन्गर ड्यूरेशन. फाइन. सो अगर वो 4-5 ईयर या 3 years का है देन इट इज़ रिक्वायर्ड टू बी रजिस्टर्ड. यहाँ उसमें ईयरली रेंट की प्रोविज़न है, ठीक है, तब भी वो रजिस्ट्रेशन रिक्वायर्ड है. और अगर ईयर टू ईयर है कि 1 साल के बाद में इसको हम रिन्यू करेंगे, ठीक है, ईयर टू ईयर बेसिस पे, तो भी वो उसकी रजिस्ट्रेशन रिक्वायर्ड है एज पर लॉ, ठीक है. 17(1)(d) यही बात करते हैं. नेक्स्ट. Section 72 of the Registration Act carves out an exception to, ये किसका एक्सेप्शन है? 17(2), ये एग्रीमेंट टू सेल वाला जो बात है वो करता है. 17(1)(b) का है, 17(1)(a) का है, सेक्शन 17(1)(d) का है. D talks about what? Lease. A talks about gift. 17(1)(b) talks about what? Non-testamentary document pertaining to the immovable property which is valuing more than 100 rupees. ठीक है, तो उसकी बात करता है. तो 17(2) किसकी बात करता है? एग्रीमेंट टू सेल pertaining to what? This 17(1)(b). तो आंसर वुड बी B here. ठीक है, अब इसको समझिएगा. ओके. See, agreement to sell is not required to be registered otherwise. But if you are entering into an agreement to sell and while entering into an agreement to sell, you are handing over the possession also. Fine. Then if the possession is going to be transferred, then it requires a compulsory registration. Why so? Because anybody whosoever has come into the possession, sale deed has not yet been executed. Now, if he in case require dispute emerges between the party, he requires to protect his possession, then therein he can use this document. Fine, or clause 17(2), that sir, it was a registered agreement to sell, and on the basis of the registration, then it could be read into evidence also, it would be taken into, and it would be appreciated and appraised by the court of law also. Okay, it is for that purpose only. So, a document which is accompanied by the possession of the property, that is required to be registered as per law now. Fine. Okay. A registration officer may refuse the registration of the document which are in a language not understood, which contain interalineations, blank, erases or alteration, both A and B. We have just discussed it. इसका आंसर बताइएगा आप. अभी हमने डिस्कस किया इंट्रोडक्टरी सेशन में, दोनों ही प्रोविजन डिस्कस किया हमने. Rajesh, you are saying C, okay. Seema, okay. Rajesh, you are saying C. Anybody else want to attempt it? When can, जब मैंने बोला कि रजिस्ट्रार जो रिफ्यूज़ कर सकता है डॉक्यूमेंट को रजिस्टर करने के लिए, ये दोनों ही ग्राउंड के ऊपर में, ठीक है, वो सेक्शन आपका है 19 and 20. If the language is not understood by the registrar and it is not accompanied by the translation, true translation of the document, or if there are blank or the alteration or the inalienation, unless or until it is, the sign is there of the attesting party, तब तक वो रजिस्टर नहीं होगा. So answer is both A and B in this case. Priya is right, C, Virender, C, right, good. ठीक है, सेक्शन आप जरूर याद रखिए 19 and 20. Section 21 of the Registration Act applies to non-testamentary document relating to immutable property, non-testamentary document relating to movable property, testamentary document relating to movable property, testamentary document relating to 34 immovable property. ये 34 गलत आ गया बीच में. Testamentary document relating to immovable property. Answer it. We have discussed it in the introductory section. Priya, you are saying A, Virender, you are saying A. Anybody else would like to attempt this? Yes, you are right. A is the answer. As I said, that non-testamentary which becomes operative immediately. Fine. So 17(1)(b) deals with it relating to the immovable property. ठीक है. और 21 में मैंने ये बोला था कि if any document is pertaining to the immovable property, the proper description of the document, including the map, boundaries, everything is required to be submitted before the sub-registrar or the registrar as the case may be for registration. ठीक है. तो आंसर वुड बी ए है 21 का, कि अगर इमूवेबल प्रॉपर्टी से पर्टेनिंग कोई डॉक्यूमेंट है तो उसकी रजिस्ट्रेशन तब होगी जब उसके साथ में सपोर्टिंग डॉक्यूमेंट विच आर रिक्वायर्ड टू आइडेंटिफाई द प्रॉपर्टी क्लियरली दैट हैज बीन प्रोवाइडेड. राइट, नेक्स्ट. Section 23 provides the time for presentation of document for registration before the proper office of 4 months from the date of execution. This is what we discussed in the introductory section. I think everybody would attempt it rightly. Please, I need to know your answer. 4 months, 2 months, 3 months, 6 months. कहाँ से कहाँ तक?